Good morning, everyone. Ciao. I am Peggy West, the event organizer, and I'm excited that we've got a super presentation this morning coming on covenant enforcement. Hopefully, the information today that you hear will help you navigate through and give you a better understanding of your board member responsibilities regarding your covenants or your documents. Thank you for choosing us today on our webinar. I'm going to let the housekeeping go to our moderator today and let him explain all those things. And I'm just going to get right into introducing our sponsors for today. Let's start right away with Vinteum software. Vinteum is the specializing in websites for the new requirement. So Laura, tell us about yourself and tell us about what Vinteum's doing.
Absolutely. Thank you very much, Peggy. Hi, everybody. My name is Laura. I'm a sales executive here at Vinteum. So, yes, we specialize in providing software and products for pretty much everything that has to deal with residential management. So, if you are either a board member or you're a property manager and you are in Florida, maybe you need someone to help you making your website, to create your portal for your residents, for you, to make your work a lot easier with our tools. This is what we're here for. We will definitely do the whole work for you guys. You wouldn't even have to create the website at all. And the best part is that right now we're running on a Cyber Week promotion. So not only you're going to have a great partner with you, but also a great discount. So I also know it's budget season. If you want to save a little bit of money these days, hit us up. We're gonna go ahead and send our information through the chat. So if you're interested on it, just let us know and we'll be more than happy to assist you with everything. Thank you, Peggy.
Okay, great. Awesome. Okay, next I want to introduce Jamie Gelfand from First Citizens Bank. Jamie, tell us about yourself.
Hi, Peggy. Good morning. My name is Jamie Gelfand. I'm the regional sales officer at First Citizens Bank. First Citizens is a 125-year-old top 20 bank. In the CAB Community Association Bank Division, we provide all the association's banking needs. We integrate with over 20 software for API integration. We have loan opportunities, FDIC protection, and all of your banking needs. I'll put my information in the chat, and I know you're going to have a great class today.
Okay, thank you so much. Next, I want to introduce Daniel Baum. He's with COA Solutions, outstanding broker if you need insurance. Daniel, introduce yourself, please.
Thanks, Peggy. Hi, everyone. Nice to see everyone again. My name is Daniel Baum. I am the founder of COA Solutions of Florida. We specialize in commercial property and casualty insurance, specifically for condominiums, HOAs, and multifamily properties, otherwise known as habitational cat risk. The great news is we have officially exited hurricane season. December 1 is the official date that hurricane season is over. So that's fantastic. That means we went through another season without any major catastrophes and any major problems for the carriers. And what that means for you and your community is that we should continue to see lower rates on the property side. So December 31 is a major renewal date. May 31 is a major renewal date. These are the dates that lots and lots of associations come up for renewal. And if yours is coming up anytime going forward, this is the perfect time to be reviewing and making sure you've got the lowest possible coverages, checking to make sure your agent is out there shopping for you. I am seeing some upward pressure on general liability policies and directors and officers policies, not uncommon, especially we've had some of the criminal issues that have gone on in some poorly run associations in the last year or so. So seeing some upward pressure on those is normal. Thankfully, it's not an enormous amount. It's fairly mundane. So again, you should be looking for policies that are either staying the same from last year or especially on the property side going down. If you're not, please feel free to reach out to me. I do offer a complimentary review of policies. There's no cost, there's nothing to sign. I'll just take a look at your policies and tell you if I think you have the lowest possible option or if there's something better out there. That's it for me. Have a wonderful webinar today. Enjoy the presentation, and I look forward to seeing you all on the next one. Thanks, Peggy. back to you.
Okay, thank you so much. Great introduction. So now I want to move on to introducing Ruthie from Kaiser Air Conditioning. Ruthie, tell us about yourself and what you're doing for associations.
Yes, hello everyone. Thank you, Peggy, again for connecting all of us. We always appreciate what you do and all the work that goes on behind the scenes. So thank you for what you're doing. I am the marketing director here at Kaiser Air Conditioning. We are locally owned and operated and have been in business here for 20 years in South Florida. We serve Broward, Palm Beach, Martin, and St. Lucie counties. So if you have residents or properties in those areas, we are here to serve you any way we can. We're open 24/7, and that includes during the holiday season. So if you have residents or if you have emergencies on your property that require attention from an HVAC vendor, please, please, please let me know, and I will make sure that you guys are taken care of right away. 9 times out of 10, we can resolve this situation same day. So we want to keep you and your residents comfortable and cool throughout the holiday season. Even as, you know, in Florida, we have a little bit of a different winter than maybe elsewhere. So let's make sure you guys stay cool. Yes, absolutely. Also, just one quick note, if you guys have seasonal residents that are coming in from out of town and they haven't been to their property maybe in a few months or, you know, usually around 6 months, we definitely suggest that some sort of tune-up or something be done on their unit. So if you have a seasonal resident and you're looking for kind of maybe a special offer for them, reach out to me. I can hook it up for you, take care of them for you, and you'll get all the credit. You'll come out looking like a star. We promise we'll make you look good. So we have the team, the trucks, we have enough to serve you guys all through the holiday season. So thank you again, Peggy, and hope you guys have a wonderful webinar. I'll leave my information in the chat.
Okay, great. Thank you so much. And also, I didn't mention it, but I want to remind you, all of these sponsors' contact information will be sent to you on a sponsor sheet following the webinar. Okay, next I want to go on and introduce Shawnee Haas. Shawnee's with Munyon. Shawnee, tell us about yourself and the company. What are you guys doing lately?
Hi, I'm Shawnee Haas. I am the marketing manager with Munyon Painting. We are about to celebrate 75 years in business. We are third generation owned, and we've been, over the 75 years, we've been serving multiple communities all across Florida. That's in Tampa, Orlando, West Palm Beach, just everywhere and anywhere in Florida. We're very passionate about making communities beautiful and having that beautiful paint lasting long term. So we do offer warranties on our paint. And right now we are also doing a free estimate. We know everybody is in budget season. So if you want to contact me, I can set up someone to come look at your property and we can arrange a bid or a proposal for you to use or peruse in the next year. Thank you.
Okay, very good. Okay, next I want to introduce Dahlia Anise, Esquire. She's an attorney for Legacy Life Planning. Dahlia, tell us what you do. You do something really special for everybody.
Okay. Well, thank you, Peggy. Yes, my name is Dahlia Anise, estate planning attorney with Legacy Life Plan. So I do wills, trusts, and capacity planning. And this is a great time to really be thinking about this. We're all thinking about gifts for our families. This is the biggest gift we can give them because once you lose someone, it's very traumatic. And we don't want our loved ones to be scrambling, trying to find money to pay for our bills, because unfortunately, when someone passes, their bills do not pass with them. There's home upkeep and so forth. So I really would like to incentivize you to book a 15-minute call with me, just as a discovery call, and it's free, just to see if we're a good fit, to see if you would be, you would need my services. And for the month of December, I have a few spots left. I want to tell you that I will give you, it's $1,000 off of your plan. We're going to be doing a whole lot of things. So I'm going to put my information in the chat to book this 15-minute call with me. And let's see, how I could be of service to you and your family. Thank you, Peggy.
Absolutely. You're welcome. Okay, I see from United Professional Engineering, we have Siobhan Gonzalez has signed on. Welcome, Siobhan. Can you introduce yourself and your company?
Hi, good morning, everyone. Welcome to the
Morning.
webinar. Yes, my name is Siobhan Gonzalez. I am the business developer here at United Professional Engineering. We are a full service structural engineering firm. So we've been serving South Florida and condominiums for over 20 years. So we do all things special inspections, milestone, phase one, phase two, concrete restoration and repair, all your needs as far as reserve studies as well. If you have any questions regarding engineering, we are here to serve you. Our team is licensed, experienced, and experts in the industry. Our president and owner, he leads our company for over 26 years. He's the standing president of the Florida Structural Engineers Association. He was also a contributor and part of the Surfside Working Group. So we are huge on safety, compliance, and education. We want to educate you, empower you to make your best decision and be that resource for you. So happy holidays to you and yours. Deadlines are upon us as far as budgets for next year and compliance deadlines. So if you have questions about that or unsure where your association stands, I'm going to leave my information and you can contact me. I'll be more than happy to help.
Okay, great. Thank you so much. And happy holidays to you. I have a few sponsors that did not make it today, but I do want to mention them because they are very active in the associations. They're actually great trusted advisors. If you need a bid, get their name and information off the sponsor sheet. I'll start with Best Roofing. Diana Alert is the representative on there. Best Roofing's been around for a long time, over 50 years. Next is Faster IO, is a streaming service. You can take this service anywhere in the country with you. Great service to have in addition to your home or your residence. Next, I want to introduce City Quiet Windows and Doors. Ben Friedman is the owner. He's been around also a long time. He's got 4 offices around the state, so reach out to him for a bid if that's time of year for you. We also have PD Concrete. PD Concrete has been around over 20 years now. They just celebrated year 20, and they are very excited to give you a proposal as well. Hafer Company. Hafer is a audit and CPA firm, full service with 4 offices around the state as well. If you need any information, reach out to Nicole Johnson or Mark Landez. They are always ready to give you an immediate appointment to see what your needs are. Then we have the paving lady. Dawn Miller is the representative. She is now going all the way up to Orlando. So Orlando, Central Florida, south down to the Miami area. And they're being very aggressive in their quotes as well. We also have J.R. Fraser. J.R. Fraser is a reserve study program. We have Sundeep J, owner, and his wife, Patty J. Very competent. They purchased this service over 10 years ago. They themselves have been reserve specialists for 10 years now. So very qualified, and they will help you with your reserves. Last but not least, I want to mention Southwest Elevators. Brooke Cavender is not on today. She is a 4th generation owner. She is the sales manager for the state of Florida. If you need anything regarding your elevator, please reach out to them. With that, I'm going to turn this over to our moderator for today. We have Jeff Solomon with Kaye Bender Rembaum. Jeff, I'm going to let you do the introductions from here for Kaye Bender and also for Danielle.
Peggy, thank you so much. Thanks to all of our sponsors for making this possible. Great to be here today. I'll try to be real quick here. I want to first mention the question that comes up all the time. Who gets a CEU for today? Well, if you're a board member of an HOA, okay, a homeowners association, or a manager, property manager in the state of Florida licensed, you will get credit for today. However, the information is pertinent for anybody in a condominium or a cooperative as well. So you won't want to miss out on the information today. But for CEUs, it's board members of an HOA and for our community association managers. And as Peggy mentioned a little bit earlier, we have the Q&A module. The Q&A module is where you're going to type your questions, not in the chat, but in the Q&A module. The chat is reserved for the vendor information, also where we're going to place the link for the required evaluation towards the end of the class. After you click on that link in the evaluation a little bit in the chat a little bit later for the evaluation, you will then get a confirmation submission screen after you submit it, and then you will instantly be able to download and save today's slides. Okay? So please keep that in mind as well. The Q&A for questions, the chat for vendor information, and the evaluation link. Try to hold off on typing your questions because a lot of the times we find our audience kind of jumps the gun and the material will be covered a little bit later in the presentation. And also, please keep it on topic and not too association specific. We don't have your documents in front of us to go that deeply into anything. And piggybacking on that, nothing today should be considered as legal advice, educational in nature only. So please don't go to a board meeting tonight and say, Danielle said this during the meeting today, during this class, and this is how it's got to be. Folks, these things coming out of Tallahassee are not always so concrete. A lot of them are vague. Always contact your association counsel if you're not sure about something. And if you don't have one, we have a pretty darn good one about to speak in about a minute here. So with that said, I want to now turn it over to one of the very few board-certified specialists in condominium and plan development law in the state of Florida. There aren't that many. It's a single digits in the numbers in the state here. This is one of them from our Palm Beach Gardens location of Kaye Rembaum. This is Danielle Brennan.
Good morning, everyone. I feel like there should be like, I don't know, like some Rocky music or something after that introduction. Thank you guys so much. Thank you, Peggy, and to our sponsors for making today possible and for thinking of Kaye Rembaum when it comes to providing these educational needs for our board members and our managers. So I'm Danielle Brennan. I am a board certified specialist in condominium and plan development law. I am one of 10 board certified. One of the board certified attorneys here is board certified in construction law. So we do have that in our back pocket as well. I am one of 24 attorneys now out of, let's see, we have our Tampa office, we have an Orlando area office, Pompano Beach office, our Palm Beach Gardens office, and we do have office spaces available in Miami-Dade by appointment. So we've grown a lot since I started here. About 13 years ago. So we can service any community association throughout the state of Florida. This is what we do day in, day out, and we can legally say that we are experts in this field because of that board certification. It's unlikely that there's an issue that will come across our desk that we haven't seen before. So I know Jeff was saying earlier that we never say never, but usually it's not our first rodeo. So we do all kinds of different issues, contract review, negotiation, enforcement, which we'll be delving into today, governing document redrafting, amendment drafting, what have you. All of it for our community associations, whatever you need, collections, we do that as well. All right, so let me go ahead and share my screen. And hopefully it kept the...
Oh, you've got this. And while Danielle's doing that, I want to answer Julie's question in the Q&A as well as others who will undoubtedly have the same question. The material will cover covenant enforceability for HOAs, condos, and a little bit about co-ops. But in terms of CEU credit, the CEU credit will only be for HOA board members. The condo CEU credit is a different class altogether. One CEU required per year, and that's legal in nature. So this is not that class. But there is information pertinent for condominiums in this class. Hopefully that makes sense to everybody.
Yeah, so for our HOA folks, after you've been board certified, you do have a continuing legal or continuing education requirement. I keep saying continuing legal because attorneys have to do CLEs. But you do have a continuing education requirement. For the most part, HOAs, directors need an additional 4 credits, whereas our condos, they need 1 credit. So for HOAs, this will count towards credit. I do believe it will be 2 credit hours, correct, Jeff?
Correct.
Okay.
Oh, yeah. It's 1 credit hour for managers and 1 credit hour for HOA board members.
Okay.
Yep.
Okay. So you'll get 1 credit hour for your HOAs.
Yep.
You have all the information. If you need to get in touch with me, feel free to ask questions afterward. I do try to respond to them as timely as possible. Again, as Jeff had mentioned, this is informational purposes only. I'm not providing any legal advice, though I am an attorney and I certainly can do so. There are a lot of other factors that go into providing legal guidance and a legal opinion, and this is certainly not the venue for that. But you can certainly reach out to us if you don't have an attorney or if you maybe want a second opinion on something. Feel free to reach out to KBR. And we'll get in touch with you. This is some information about myself, a picture of me from 13 years ago, which I still hope still looks like me. And some of my background information. I grew up down here in South Florida. If you know the school, I went to St. Thomas Aquinas High School, which I guess a lot of people know about in the area. I did work with the Miami Dolphins while I was in law school on in a volunteer program. And yeah, I've just been here for about 13 years, and I am a firm member, which is just our fancy way of saying a partner. And now I have reception calling me. Hold on one second. All right, so let's go ahead and jump into it. Today, obviously, we're talking about covenant enforcement. And the way that the course is set up, I like to think is a logical flow of information. We'll talk about the different types of covenants there could be, what our enforcement abilities are, litigation wise, and then some of the defenses that the association might face. All right, so covenant enforcement. Who's responsible for covenant enforcement? Well, it's the association, and the association is controlled by its board of directors. So really, it's the board who's making determinations regarding the enforcement of the association's covenants. We want to be sure that we're enforcing covenants uniformly so that we avoid defenses that we'll talk about later in today's course. The failure of the association to enforce its covenants in a timely manner could result in waiver or forfeiture of enforcement rights, and that's something, again, that we will delve into toward the end of the presentation. Now, what covenants, restrictions, rules, and regulations are there that can be enforced? Well, obviously, that's going to be something that's provided in your governing documents. And our governing documents consist of our declaration. In a condominium, it's usually a declaration of condominium with your condominium name. In HOAs, it could be a declaration of covenants, conditions, restrictions, and easements, or any permutation of that. We have our articles of incorporation, which is really like a formative document that says, here's our corporation. It has directors, it has officers, it has members, and the corporate powers. And then we also have our bylaws. So our bylaws are like a how-to document. How do we hold a board meeting? How do we hold a membership meeting? How do we adopt a budget? So that's our how-to document. And then finally, we have our rules and regulations. Now, typically, these are adopted by the board, and they pertain to your day-to-day living. How to care for your pets, pick up the pet poop, bring in your trash bins, maybe governing holiday lights, what have you. So those board adopted rules really stem from authority provided in your declaration, which is like your constitution, right? It sets forth all the different rights of the association and the owners. So for the most part, when we're talking about covenant enforcement, we're talking about provisions that are either set forth in the declaration or in the rules and regulations. They're not so much going to be for restrictions or provisions, conditions provided in articles of incorporation or bylaws, because those are really just corporate documents and not necessarily setting forth restrictions and regulations. So what could we possibly have to enforce? Well, there are architectural standards, particularly in homeowners associations, age restrictions. Maybe you live in housing for older persons, 55 and older. Pet restrictions, maybe you prohibit pets or regulate what kind of pets, how many pets, the weight of the pets. Restrictions on leasing and sales. A lot of associations might have a lease moratorium, meaning You can't lease your home or your unit for the first year or 2 years of owning the unit. Maybe there's a cap on the percentage of units or homes that can be rented out at any one time. Guest and occupancy restrictions, for example, guests can only be in your home for 30 days, and after that 30 days, well, then they need to be approved as if they were a tenant. Parking and vehicle restrictions. A lot of associations that have parking lots will require head-in parking so that they can see your tag, your plate. Or maybe, in an HOA, they'll require you to or prohibit you from parking over a sidewalk, what have you. And then nuisance conduct, which, kind of is essentially a catch-all. People who are making too much noise, or dogs who are making too much noise, or people that are creating just an uncomfortable or unsafe environment within your community. So those are some of the different types of restrictions and covenants that can be enforced. So now that we know what our covenants are, let's say, unfortunately, someone has violated those covenants. What do we do? So typically the first step in that enforcement action is to send the owner a notice of the violation, a courtesy notice or notice of violation, first notice of violation, whatever you may call it. The notice should include a statement of the violation, what it was that they did, cite the provision of the governing documents being violated by section, verse, whatever it is. And if the violation can be cured, describe how the violation is to be cured and a deadline to cure that violation. So, for example, if you're in an HOA, somebody's roof is dirty and they're not properly maintaining their roof, you send them a notice saying, hey, you failed to properly maintain your roof in accordance with section 1 of the declaration. Within 30 days of this correspondence, please clean your roof. And that would be your first move in getting to that covenant enforcement process. Once after you've sent that notice, if they don't voluntarily comply within that time period, let's say they don't clean their roof within those 30 days, then the association can take additional enforcement action, which could include fining, suspension of use rights, suspension of voting rights, which here is really for monetary delinquencies, not for a violation of the governing documents that's not pertaining to payment of monetary obligations. Self-help, if it's authorized by the governing documents. For HOAs and for condos, mandatory pre-suit mediation or non-binding arbitration. And finally, litigation, which is something that most associations want to avoid. And so let's delve into each one of those topics. Here you'll see the statutory references where you can find that statutory authority for your condos and for your HOAs. Condos, you'll have it in 718, Chapter 718. HOAs, you'll be in Chapter 720. If there happen to be any cooperatives or cooperative board members here, your statutory reference is going to be in Chapter 719. So, fining. The association can levy reasonable fines for violations of their governing documents, and the authority to fine does not have to be provided in your governing documents. You can use that statutory authority because it's remedial in nature. As for the fine amount, condominiums, you're restricted by statute completely. Fine cannot exceed $100 per violation, nor $1,000 in the aggregate, and the fine cannot become a lien against a unit. So you can't assess the fine amounts against the unit. In a homeowners association, it's similar but different because you do have more leeway. A fine cannot exceed $100 per violation unless otherwise provided in the governing documents. It also cannot exceed $1,000 in the aggregate unless otherwise provided in the governing documents. And a fine of less than $1,000 cannot become a lien against a unit. So when you're in a homeowners association, you do want to be paying careful attention to what your governing documents provide as to the fine amount. And if it's silent as to the fine amount, maybe this is something that you want to amend later into your governing documents to allow the association to have fines greater than $100 per violation or $1,000 in the aggregate, which will allow you to then lien for those fines against the home. So the fining process, now that we've talked about the authority, how do we get it done? So the fining process for both our condominium associations and our homeowners associations require the board's levy of that fine and confirmation of the fine by an impartial committee. So it's a two-step process as far as meetings are concerned. The fine can be levied by the board for each day of a continuing violation with a single notice and hearing before the committee. So for example, for our roof that needs to be cleaned, because if the unclean roof is there day to day, even though each day might be like a different violation, you really only need to have that one levy and the one hearing, and then you can tack on that fine for each day that the violation continues to exist. After the fine is levied by the board, then written notice of the hearing has to be provided to the member, and if it's applicable, the tenant, licensee, or invitee that's going to be fined at least 14 days before the hearing. So the board meets, they levy the fine, they send out a notice to the owner or to whomever sought to be fined that a hearing of this impartial committee will take place at a date that's at least 14 days away from the date of that notice. In our homeowners associations, let me preface this by saying there used to be a much simpler process prior to the 2024 legislative session. But in 2024, the Florida legislature decided, hey, you know what? Let's shake things up a bit, like a lot, for our covenant enforcement for our homeowners associations. So there's been a lot of different changes. Some of them don't make sense. But we're going to walk through them. Okay. So for our homeowners associations, the hearing notice has to include a description of the alleged violation, whatever action needs to be taken if the violation is curable, and the hearing date, location, and access information if the hearing is going to be held by telephone or other electronic means. So yes, in a homeowners associations, that committee hearing can be held electronically. The hearing has to be held within 90 days after issuance of the hearing notice. So you have to send the notice out for at least 14 days before that hearing, and it has to be held within 90 days of issuing that notice. The committee can hold the hearing by telephone or other electronic means, as I mentioned, and the owner has the right to attend that hearing by telephone or electronic means, which is, again, why you have to include that information in that hearing notice. Now, once we're at the hearing, the committee has to consist of at least 3 members appointed by the board who are not officers, directors, or employees of the association, or the spouse, parent, child, brother, or sister of an officer, director, or employee of the association. Again, we need this committee to be impartial from the decisions that are being made by the board, right? Because what would be the purpose in having 2 different bodies approve it if the second body is essentially going to be just an extension of the board? The role of the committee is limited to determining whether they're going to agree with whatever was levied by the board or reject it. Now, if they do anything other than approve the fine that was levied by the board, it's going to be a disapproval. So once it's been disapproved, you cannot impose the fine. Now, after the hearing for condominium associations, if the fine is levied by the board and approved by the committee, then the condominium association has to send written notice of the fine by mail or hand delivery to whomever it was that was being fined and to the unit owner. The fine payment is due 5 days after notice of the approved fine is provided. This used to be also applicable to HOAs, but again, since 2024, everything changed. So within 7 days after that hearing, the committee must mail or email written notice to the owner and to whomever else maybe was fined. And they also have to provide in that notice any applicable fines that were approved or rejected by the committee, how the person, the violator, can cure the violation if it's subject to cure, and a date by which the fine must be paid. So it's a similar notice but you do have a time frame within which to provide that notice.
Hey, Danielle,
If the
are hearing meetings open or closed is a common question. Is it something that anybody can go to, any member?
So you have to look at your bylaws. So in an HOA, your committee meetings generally do not have to be noticed, save for architectural committees. So architectural committees, you really do need to be noticing those. But it's really going to be bylaw dependent. Your bylaws may require it. Now, in a condo, all committee meetings do have to be noticed, and your bylaws can exempt committees except for committees when they're making decisions about expenditures. What's the second one? I think it's when they're determining the budget. If there's a committee determining the budget, but I have to double check that. So generally speaking, yes, you do have to notice them, but it's really going to be bylaw dependent.
Okay. Thank you. I know it comes up a lot.
Yeah. So if a violation has been cured before the hearing or in the manner specified in the hearing notice or the notice of the committee's findings, the fine cannot be imposed. So let's break this down a little bit because this was something new and it's something strange to me. Obviously, if the board meets, they levy the fine, they send out the hearing notice, and the owner comes into compliance, well, it makes sense. Okay, we don't need to have the hearing anymore. You guys have complied. Fine, we're not going to issue the fine against you. Well, now let's say the board has met, levied the fine, sent the 14-day notice, the committee met and approved the fine. And then we send our fine notice. Well, it's saying that if they cure it, then the fine cannot be imposed. Well, presumably, this means that if they haven't already paid the fine and then cured, right? But that's not really what it says. So we kind of have to read in between the lines and say, listen, if you've sent your post-hearing notice of the fine that's levied by the committee, and they've paid the fine, but then they cure, well, the fine has been imposed and paid, so it's not like you're issuing a refund of the fine, right? So it's a strange change that the legislature made here, but we have to be reasonable in its application. So that's my opinion as to how that provision is applied. If the violation is not cured and the fine levied by the board is approved by the committee by a majority vote, the committee then has to set a date by which the fine must be paid, which must be at least 30 days after delivery of the notice of the committee's findings. So when the committee is there and they're talking about the fine and they're like, you know what? We think that the board was correct in levying this fine. We're going to approve it. They have to be a little bit clairvoyant here in determining when is that notice going to be delivered, right? So you want to be sure that you're sending that hearing that fine notice, the committee's findings notice, by some kind of trackable method, whether it's FedEx delivery with a tracking number or certified mail return receipt requested, something where you can actually confirm delivery. And the committee has to add in some time to allow for that delivery. So that post-hearing notice has to be sent within 7 days of the hearing. And then the fine has to be due at least 30 days after the delivery of the notice. So you have to kind of like say, okay, well, let's tack in an additional 5 days for delivery if we're sending it by certified mail return receipt requested. So really, when you're making that determination of the date, you're going to be looking at like 45 days down the line. So they've made it pretty complicated here for that committee to determine what that fine due date is going to be. Now, what the legislature also did was limit the attorney's fees that could be collected from an owner. So attorney's fees and costs cannot be awarded against an owner based on actions taken by the board before the date set for the fine to be paid. So if you're going to initiate the fining process, you want to be mindful of your attorney's fees that you're tacking on here, because it may not be collectible at the end of the day. If a violation and a fine levied by the board is, if the fine levied by the board is approved by the committee, the violation is not cured, or the fine is not paid pursuant to that notice, then reasonable attorney's fees and costs can be awarded to the association. So there are a number of boxes you need to check in order for the association to get attorney's fees if you guys go down the fining route of enforcement. But again, as we mentioned before, there are lots of different avenues of enforcement. So maybe fining isn't the best option for homeowners associations, right? Notwithstanding any provision to the contrary in your governing documents, an HOA cannot levy a fine for leaving garbage receptacles at the curb or the end of the driveway within 24 hours before or after the designated garbage collection date or time. Leaving holiday decorations or lights on their home longer than what's allowed by the governing documents, unless they've been left up for longer than 1 week after the association provides written notice of the violation to the owner. So a lot of association boards have been like, well, why do we, considering these restrictions, why are we even bothering with trying to regulate these things? Well, it's not to say that you shouldn't have rules pertaining to when people should bring in their trash bins or when people should be taking down their holiday decorations. It just means that there are a couple of procedural steps you have to follow or boxes you have to check in order to enforce them via a fine and use right suspension, as we'll get into later. So they're certainly still worthwhile having, but in order to fine for those or suspend use rights, as we'll see for these particular violations, there are a couple of things that we need to consider. So for example, if it's the lighting decorations, you have to send a notice, allow them a week to remove it, and if they don't, then you can start doing the fine or use right suspension. So since we're mentioning the use right suspension, this is a great segue into delving into that particular enforcement route. Again, the statutory references are there for condominium associations and homeowners associations. So an association can suspend the right of an owner or their tenant, guest, or invitee to use the common areas or common elements, common facilities, if that member is more than 90 days delinquent in paying a fee, fine, or other monetary obligation due to the association, or for failing to comply with any provision of the association's governing documents. So recall that the ability to fine is only for failing to comply with any provision of the association's governing documents. Well, suspension of use rights is special because it's for both failing to comply with any provision of the association's governing documents and for those monetary delinquencies that are more than 90 days delinquent. As we'll come to see, and as I previously briefly mentioned, the suspension of voting rights is only available for that monetary violation, monetary delinquency greater than 90 days, and we'll delve more into that soon. So suspension of use rights can be done for either type of violation. It's just important to note that if it's a delinquency, it has to be greater than 90 days delinquent, not on the 90th day, on the 91st day. For our condominium associations, a use right suspension does not apply to whatever limited common elements are attributable to that unit. Maybe it could be their parking space or their balcony. Common elements needed to access the unit, utility services provided to the unit, parking spaces, or elevators, right? They still need to be able to access and live in the unit, notwithstanding the use right suspension. So it's really going to apply to your recreational facilities. Maybe you have a pool, cabanas, what have you. Similarly, for our HOAs, the use right suspension is not going to affect the common areas used to provide access or utility services to the parcel, including vehicular and pedestrian ingress egress, coming in and out from the parcel, and the right to park. So once you've got your use right suspension, just note that it's not going to apply to those particular areas, but it would certainly apply to the recreational facilities. Maybe you have tennis courts or something like that, a pool. The suspension will apply to the owner and when it's appropriate to their tenants, guests, or invitees, even if the delinquency resulting in the suspension arose from less than all the multiple units or parcels owned by the owner. So let's say an owner owns 2 or 3 units or homes within a community, but is only delinquent with regard to one of those homes. Well, once you levy that use right suspension against that particular owner for the delinquency on that one home, it's going to be applicable to the other homes that they have within the community, which makes total sense, right? Because the purpose is to keep them from using the common facilities so that they pay. But if they're able to claim, oh, well, I'm not using it as the owner of this lot, I'm using it as the owner of this other lot, it kind of defeats the purpose, right? So for our monetary violations, again, it has to be more than 90 days past due. The suspension is approved by the board at a properly noticed board meeting. For these types of monetary violations, there's no need to go out for an impartial committee approval. It's done by the board alone. Once the board has approved it, the association has to notify the owner and, if applicable, occupant, licensee, or invitee. For our condo associations, by mail or hand delivery, and for our HOAs, by mail, hand delivery, or by email. And the suspension will end when the delinquency is paid in full. Now, when levying use right suspensions for non-monetary violations, we follow the same type of process that we did for the fining. So we have our board's levy of the use right suspension. Then we send a notice out to the person who's being suspended at least 14 days before the hearing. The hearing notice for our HOAs has to provide a description of the alleged violation, what they need to cure the violation if it's subject to cure, the hearing date, location, access information if it's going to be held by telephone or electronic means. The hearing has to be held within 90 days after issuance of the hearing notice. The committee, again, can hold the hearing by telephone or other electronic means, and the owner has the right to attend by those means. The committee must consist of 3 members. Again, this is just review of what we discussed earlier, who are appointed by the board but are not officers, directors, or employees of the association, or any of their spouses, parents, children, brothers, or sisters. The role of the committee is limited to determining whether they should approve or reject the use right suspension levied by the board, and if they don't approve it, then it's a rejection. After the hearing for our condominium associations, if that use right suspension levied by the board is approved by the committee, then the association must send written notice of the suspension by mail or hand delivery to the unit owner, and if it's applicable, to any tenant, licensee, or invitee. So they will get their little love letter that their use rights have been suspended. For our homeowners association, similar to what we were discussing about fining, within 7 days after that committee's hearing, the committee must mail or email written notice to the owner, and if applicable, to any occupants, licensees, invitees of the owner's lot, of the committee's findings, including any applicable suspensions that the committee approved or rejected, how they can cure the violation if it's a violation subject to cure, and how they can fulfill the suspension. After the hearing, so for our homeowners associations, again, some weird provisions that were input by the 2024 legislative session. If a violation has been cured before the hearing or in the manner specified in the hearing notice or notice of the committee's findings, the suspension cannot be imposed. So after the board, again, when it's prior to the hearing, we understand, okay, the committee isn't going to be approving a use right suspension at their committee hearing once the owner or the tenant, whomever it is, has brought themselves into compliance. It makes complete sense. But when the committee has already approved it and sent their notice, presumably once they send the notice, the use right suspension is going to take immediate effect. So it's been imposed. The only thing that I can think of that would reasonably make this make sense is that, okay, after they've sent the committee's post-hearing notice saying, yeah, they approve the use right suspension, it's immediately effective, Perhaps the suspension is for a certain number of days, 30 days, what have you, which is pretty typical. Maybe what this means is that if an owner or tenant, whoever it was that was in violation, cures the violation prior to the end of that use right suspension period, well, then the use right suspension has to immediately terminate. And that would make sense, but that's not what's provided by the statute. So it makes it a little difficult to apply. But in my view, that's a reasonable interpretation of this particular statute. So if the violation has not been cured and the suspension was levied by the board, approved by the committee, then a reasonable attorney's fees and costs may be awarded to the association, but they cannot begin to accrue until after the time for an appeal has expired. So what's interesting here is that there's an appeals that's mentioned in the statute, but no appeals process is provided for in the statute. This is something that's going to be entirely governing document dependent. I have seen some documents include an appeals period, but I mean, it's maybe one out of 200, that I've looked at that may have this appeals process in there. This does not mean that owners have a right to an appeals process, because again, this isn't something that's described in the statute. Again, with our special considerations for our homeowners associations when it comes to leaving garbage receptacles out at the curb or leaving holiday decorations, you do have to provide that notice and allow them a week to remove the holiday decorations before you can go ahead and suspend use rights for that violation. Or for garbage receptacles, they have to be kept out more than 24 hours before or after the designated garbage collection day or time before you can enforce it by a use right suspension.
I want to bring up one point that comes up quite often about being reasonable. Like if you're going to impose fines for a particular owner, for example, okay, the grass is too high, well, whatever it is, the weeds are knee high, but at the same time, while the manager's thinking about imposing a fine or a violation, the public space is just as bad looking. So that's what I mean by being reasonable. So when you're out there conducting inspections for fines, be cognizant of what the common areas look like. It's kind of wouldn't be the greatest thing if you're fining somebody for something they're in violation of when the public area is looking just as poor. Am I making sense?
Yeah, you're making sense. Obviously, I think the whole thing about being within a community association is that we all want to be good neighbors.
Right.
Just, lead with a good foot. And, another key to reasonableness is be reasonable in the amount that you're fining.
Right.
If you're a homeowners association and your governing documents allow a fine to exceed $100 per violation, well, it would be unreasonable to fine someone $500 because they left their trash bin out for 2 days.
Right.
So there are different aspects that go along with reasonableness. I think we need to not lead with our head, not with our heart sometimes.
Yeah.
When it comes to these issues, and
Well
a
said.
lot of issues when it comes to homeowners associations.
Yeah.
I mean, it does boggle the mind sometimes, but I guess that's why we're in business, right?
Yep. Yes, ma'am. Well said.
All right. So we've talked about fining, we've talked about suspension of use rights. Now let's go into that special category of suspension of voting rights. Now, the authority to suspend your voting rights. This is only going to be applicable for delinquencies greater than 90 days. Not the 90th day, on the 91st day, the association can then suspend voting rights. The suspension will apply to the member, and they say here to the members, tenants, guests, invitees, even if the delinquency resulted in the suspension arose from less than all of the multiple units owned by a member. Similar to your use rights suspension language, if they own multiple, but it's to the one, it'll apply to all of them. And having it apply to tenants, guests, or invitees doesn't really make much sense here for a voting right suspension, considering that only members have voting rights, I would say 100% of the time. For our condominium associations, there are some additional hurdles that you have to take into consideration that were added, I don't know, several years ago. The monetary obligation has to be more than $1,000. You have to provide proof of the obligation to the owner at least 30 days before the suspension takes effect, and at least 90 days before an election, the condominium association has to notify an owner that their voting rights may be suspended due to non-payment of a monetary obligation. Reason being is the legislature wants people to be able to participate in that election. So the suspension has to be approved by the board at a properly noticed board meeting. Again, that notice has to be provided by mail or hand delivery. For our condominium association, for our homeowners associations, it's mail, hand delivery, or email. What's interesting is that when the 2024 legislature made all of those crazy changes to the HOA Act, they did at least allow the homeowners associations to use more modern technology here. So we do have the ability to use email more so than condominium associations in this regard. A voting interest which has been suspended is subtracted from the total number of voting interests. So it's like it doesn't even exist. You don't count it, and when calculating what's a quorum requirement, or when you're conducting an election or approving any action, it's as if it never existed. And then the suspension ends upon full payment of all obligations currently due to the association. Now, although the voting rights suspension power is provided by statute, and in the same statute that fining and use right suspension is provided in, there is a caveat to this authority that was created by this particular statute. There's a particular case. And in this case, they were basically saying that, well, the declaration didn't provide for suspension of voting rights as a means to remediate or collect assessments. And there was no Kaufman language. Kaufman language, if you've been to one of our board certification courses, you've heard before, I'm sure. It's a case that essentially says that if you have reference to the applicable statutes, either Chapter 718, Chapter 720, Chapter 719 of the Florida statutes, as amended from time to time, then the substantive real changes made to the statutes are incorporated into your governing documents as if they were drafted in those documents. So if you don't have that language, then we have to go into like a deeper analysis to determine, okay, what statute is applicable to your community association. And that's essentially what they were saying here, is that you don't have it in your declaration, and it wasn't included into your declaration by change of statute because you don't have Kaufman language. Therefore, you don't have the right to suspend voting rights. So when we're looking at the governing documents, we want to be sure that we are checking to make sure that the voting rights suspension authority is provided in your governing documents due to this particular case. Now, when talking about case law that has really muddied the waters, there's quite a lot of case law in the self-help arena to talk about. Self-help, so what is it? It's the association's authority to go into the unit or go onto the lot to make take the remedial measures and then charge back the costs to the owner. It's going to be completely governing document dependent. So in your association's declaration, it'll probably be something like the association's the owner's failure to properly maintain the property authorizes the association to go in, do the work, and to levy the costs incurred by the association as special assessment or individual assessment against the owner. And here are some examples of that for you. So through the years, the associations have relied upon court decisions that routinely held that Florida statutes expressly authorize the association to get an injunction, meaning court ordering a person to do something or to not do something. And that superseded the common law standard of requiring that there be no adequate remedy at law before a party can seek an injunction. So we essentially have two different courts, right? We have our court at law and a court in equity. And what our court in equity says is you need to exhaust whatever remedies you have at law before you can go into the court of equity and seek an equitable order forcing someone to do something or not do something, right? So really we're talking about money versus making people do things or not do things, right? So the association would have to first exhaust its legal remedies or its remedies at law before it could go into a court of equity. But courts have held that, well, no, you don't have to do that because Florida statutes expressly authorize the association to go for an injunction. However, there was some case law recently that basically said, no, if your association's declaration provides for self-help authority, then you need to at least attempt to do self-help before you could then go into a court of equity and file a lawsuit seeking an injunction. There's actually been a lot of change in this particular landscape. As I say here at the very bottom, there's a certified conflict between district courts of appeal. So most recently, the 4th District Court of Appeal, which is here in our area, in the Palm Beach area, I do believe Broward as well. I don't know if it's in the county north of us. I'd have to look at the district map, but the 4th DCA has said, no, we don't agree with that 2nd DCA and 6th DCA. We think that because Florida statute says that an association can use at-law remedies and equitable remedies, then they don't have to exhaust all of their legal remedies before they can go into a court and order someone to do something. So 4th DCA has come out and said, you don't have to use your self-help authority before you go into a court and ask them for an injunction to force the owner to make the remedial measures themselves. So hopefully we'll be seeing something come out from the Florida Supreme Court, which probably will take, however many years, but this has been a certified conflict, so we shall see what the Florida Supreme Court ends up saying about this in time. So let's say the association has sent its notice out, gone the other avenues, fining and use right suspension, potentially a voting right suspension, but they're still not obtaining compliance. And this is really, I wouldn't say voting right suspension because that's for delinquencies, but fining and use right suspension, and they're not getting anywhere. Well, then we would next turn to dispute resolution. And it is different for condominium associations and homeowners associations. So we'll start in number order with our 718 folks. So we have the option of arbitration or pre-suit mediation now. This was a change done in the statute, I don't know, maybe a few years ago. Before you can go into court for litigation, a party to a dispute has to either petition the Division of Florida Condominiums, Timeshares, and Mobile Homes, which we call the division for short, for non-binding arbitration, or initiate pre-suit mediation in accordance with the procedures that are provided in the HOA Act. However, election and recall disputes have to go to arbitration. They're not eligible for mediation. Or you can file them with a court of competent jurisdiction, but a lot of people don't do that. They'll go to the division because going to court is more expensive. Every arbitration petition received by the division challenging the legality of the election of any director must be handled on an expedited basis. Makes sense because usually there's an election every single year. So unless you want your cause to be moot, you really do need to be handling those on an expedited basis. Mandatory pre-suit dispute resolution procedures don't apply to non-residential condominiums unless it's provided for in their declaration. Obviously, our non-residential would be like our commercial associations, commercial condominium associations. So what disputes are eligible for our arbitration? Except for disputes involving condominium termination, the only disputes eligible for arbitration are those that exist between unit owners and the condominium association or its board of directors. And it means any disagreement between two or more parties that involves the board's authority to require a unit owner to take action or not to take an action involving the unit or the appurtenances thereto. Think like maintenance or making alterations, alter or to add to common area or the common elements, or the failure of the association to properly conduct elections, give adequate notice of meetings or other actions, properly conduct meetings, or to allow inspection of books and records. Now, the plan of termination, excuse me, is going to be pursuant to that section 718-117. Hopefully, our associations aren't having to face terminations, but I know that a lot of associations are struggling right now with the SIRS and all the reserves, which thankfully is not today's topic, but I feel for all of our condominium association owners and boards out there. So what disputes are ineligible? So except for disputes involving condominium termination, disputes between or among owners or between or among groups of owners and tenants are not eligible for arbitration unless the association is somehow a party. Disputes that are with regard to title to a unit or common elements, enforcement or interpretation of warranties, like a construction warranty, levy of a fee or assessment, collection of assessments, evictions, anything having to do with tenants, breaches of fiduciary duty or claims due to damage to a unit based upon the association's failure to maintain the common elements. All of those are not going to be subject to arbitration. You can go directly to court for those issues. A petition for arbitration will not be accepted, which involves issues that are moot. Moot meaning they're no longer of issue. Abstract or hypothetical, they're not going to answer the what if controversies. There has to be like an actual dispute or controversy in effect right now in order for the arbitration section to take on the petition. A petition that alleges the association's failure to enforce or properly enforce the condominium documents, unless that controversy would otherwise constitute a dispute, or a petition that alleges the association's failure to properly repair, replace, or maintain the common elements, unless the petition also alleges how their use of the common elements has been affected as a result of that failure. So there are lots of different ways in which the arbitration section can say, you know what, this dispute isn't ours. We don't have jurisdiction, and kick you out and put you into litigation. Where controversy involves disputes that are eligible and ineligible for arbitration, then the arbitrator must determine by order whether those ineligible disputes may be severed from the controversy so that the remaining eligible disputes may be arbitrated. Again, this is all a question of their jurisdiction and what they can hear and what they cannot hear. All petitions must be completed using a division-approved form. This is something that you can get from their website. The petition must recite and have attached to them supporting proof that the petitioner gave the respondents advance written notice of the specific nature of the dispute, a demand for relief and a reasonable opportunity to comply, and notice of their intention to file arbitration petition or legal action in the absence of resolution of that dispute. Failure to include the allegations or proof of compliance with these prerequisites requires dismissal without prejudice. Without prejudice simply means that you can bring the petition back to the division once you've complied with those prerequisites. The petition must be accompanied by the payment of a $50 filing fee. I'd have to double check to make sure that that fee is still correct, because I know that they recently did some fee adjustments, but it's a nominal fee to file the petition. A copy of the petition has to be provided for each named respondent, and filing an arbitration tolls the applicable statute of limitations. Statute of limitations is the amount of time that you have to bring litigation for a particular issue. Once the petition has been received, the petition must be promptly reviewed by the division to confirm whether or not there is actually a dispute. Again, we're not talking about hypotheticals or moot issues here. Whether they've paid the filing fee and whether they've complied with the advance written demand requirement. Once that has been confirmed, then the division assigns or enters into a contract with an arbitrator and serves a copy of the petition upon the respondents. Now, the arbitrator must conduct a hearing within 30 days after being assigned or entered into a contract, unless the petition is withdrawn or there's a continuance for good cause shown. Now, with regard to withdrawal, a petitioner can withdraw their petition at any time in writing, directed to the arbitrator without prejudice to refiling. Again, without prejudice means that they can bring that same issue to the division. A request for continuance has to be made in writing, and except in cases of emergency, must be made at least 10 days before the date of the final hearing. So there are some circumstances in which continuances are granted by an arbitrator. Once the respondent is filed, once the respondent has received the petition, and then they have to file an answer within 20 days after receipt of that petition. Before filing the answer, the respondent can file a motion which opposes the petition on certain aspects, like lack of jurisdiction, insufficiency of process of service, or failure to state a cause of action, or join indispensable parties. So these are preliminary things, just like the division looks at jurisdictional matters and payment of the fees before they're willing to say, okay, yeah, we'll take this on. These are like those jurisdictional prerequisites that the respondent can say, hey, no, this is not appropriate because of these reasons. That doesn't go to the actual merits of whether or not, the petition is worthwhile. All answers have to be completed using a division-approved form. Again, this is available online. And the answer must include all defenses, unless it's otherwise determined by the arbitrator. Any defense that's not stated in the answer is deemed waived, except as to jurisdiction. Obviously, if they have no right to hear it, that is still going to be something you can bring up later. A response to all facts contained in the petition. Any facts that are not specifically denied are deemed admitted. So you want to be sure that when you're responding or when your attorney is responding to these things, that all the facts that were alleged are either being admitted or denied, because if they're not denied, then they're automatically admitted. The answer cannot include a request for relief against the petitioner, meaning like a counterclaim. So when you're in litigation and someone brings a suit against you, you can then bring claims against them as counterclaims within the same litigation. You can't do the same thing in arbitration. In arbitration, you have to file a new petition. They're not going to hear a counter argument or counterclaims, excuse me. Now, even though you've been into even though you've been into arbitration and your dispute is subject to arbitration, the arbitrator can then kick you guys out and put you into mediation at any time, even if the parties don't agree to it. So you guys can go into arbitration thinking, okay, this is the proper venue. And then the arbitrator says, no, you guys need to go ahead and mediate this. And also before or after the respondent files its answer, any party can request that the arbitrator refer the case to mediation. If it's referred to mediation by the arbitrator will provide the parties with a list of division certified mediators, and then the parties then select an acceptable mediator. If they're unable to agree to a mediator within the time provided by the arbitrator, then the arbitrator appoints the mediator. If the case is referred to mediation, the parties must attend the mediation once it's scheduled by the parties and the mediator. Any party that fails to attend the mediation without permission or approval of the arbitrator or the mediator is subject to sanctions. Sanctions meaning penalties. They can strike any filed pleadings, enter an order of dismissal or default, and award costs and attorney's fees incurred by the other party, right? So it's pretty severe. The parties share equally the expense of the mediation unless they agree otherwise, and mediation proceedings are privileged and confidential to the same extent as court-ordered mediation and to the same extent as pre-suit mediation process for our homeowners associations, as we'll discuss. If the mediator declares an impasse after that mediation conference, the arbitration proceeding terminates unless all parties agree in writing to continue the arbitration proceeding. In that arbitration proceeding, the arbitrator cannot consider any evidence relating to that unsuccessful mediation. Again, this is a confidential process, except in a proceeding to impose sanctions for the failure to appear in the mediation conference. If the parties do not agree to continue arbitration, then the arbitrator will enter an order of dismissal, and then the parties can go into court. At any time after filing a petition and answer, if there's any answer, the arbitrator will enter a summary order, final order denying relief pursuant to the petition if there's no disputed issue of material fact, and the arbitrator finds that there no preliminary basis for relief has been demonstrated in the petition. Once the answer has been filed, then the arbitrator will enter a summary final order awarding relief to the petitioner if there's no disputed issues of material fact and the arbitrator finds that there's no meritorious or worthwhile defense in that answer. Now, we've gone through all the arbitration pre-stuff, meaning petition, answer, maybe there have been some motions filed and denied. Now we're at the point we're at a hearing. The arbitrator sets the time and place for all final hearings. Hearings are usually held by telephone conference or like a Zoom, something like this. And you can have witnesses there as well. The parties, it's like litigation light. The parties will have their opportunity to present evidence, witnesses, cross-examine witnesses. There are objections there. So it is very much like litigation light. Unless otherwise ordered by the arbitrator, the petitioner presents its evidence and witnesses, then the respondent does. Again, similar to litigation. The arbitration decision must be rendered within 30 days after the hearing and presented in writing to the parties. And in the final order, the arbitrator may grant monetary damages, declaratory relief, or any other remedy or relief which is deemed just and equitable. Again, we're hearing equitable, meaning they can tell parties to do something or not do something. So we mentioned before that the arbitration proceedings are non-binding. So arbitration does become binding at some point. If all parties in the arbitration agree to be bound in writing, filed in arbitration, then it will be binding. An arbitration decision is also binding on parties if a party does not file a complaint for a trial de novo, meaning a new trial, in a court of competent jurisdiction within 30 days. And once it's binding, any party to the arbitration can enforce that arbitration order in court. If the petition is granted, the petitioner is entitled to recover reasonable attorney's fees and costs incurred in the proceedings. So they're, it's kind of like a penalty to the person who didn't comply with the order. So with regard to attorney's fees, the prevailing party in an arbitration is entitled to award of reasonable attorney's fees and costs that was incurred in that arbitration proceedings in preparing for and attending any scheduled mediation as might be determined by the arbitrator. The parties can seek to recover any costs and attorney's fees incurred in connection with the arbitration and mediation as part of the fees and costs that can be recovered by the prevailing party in any subsequent litigation, right? Because remember that arbitration and mediation are all prerequisites to going into court. So we are not only just talking about attorney's fees that might be incurred for those pre-litigation dispute or for litigation, but also for those pre-litigation attorney's fees and costs. The party who files a complaint for a trial de novo will be assessed the other party's arbitration costs, court costs, and other reasonable costs for testimony, evidence incurred after the arbitration if judgment at trial is not more favorable than the arbitration decision. So if somebody comes out of arbitration not liking what the arbitrator ordered and then files a trial de novo, and at trial de novo, they don't get something that's better than what they got at arbitration, well then, sorry, buddy, you're going to end up having to pay attorney's fees and costs. So you want to be taking that option or avenue very, very seriously. Now, for dispute resolution for our homeowners associations, disputes between the association and the owner, some are subject to pre-suit mediation, others you can go straight to court. Disputes that are subject to pre-suit mediation include use or changes to parcels or the common areas, amendments to the governing documents, meetings, either, whether they be board, committee members, access to the official records and covenant enforcement. Disputes that are not subject to pre-suit mediation, anything having to do with money, enforcement of a prior mediation settlement agreement, eviction or removal of a tenant or occupant from a parcel, breaches of fiduciary duties, those go to court, and recall and election disputes are within the division's jurisdiction. So even though, as you know from the long title, Division of Florida Condominiums, Timeshares, and Mobile Homes, homeowners associations are not part of that long list, but they do still have jurisdiction over recalls and election disputes. Now, a pre-suit mediation procedure is pretty well laid out in the statute. It is pre-suit, so you do have to do this before you can go into litigation for a dispute that's going to be subject to pre-suit mediation. You do have to send a demand, and there is a form that's provided in the Florida statutes. And then you serve that demand by certified mail, return receipt requested, and a copy by regular mail to the address of the responding party. The demand to participate in pre-suit mediation must include a list of 5 certified mediators. Excuse me. And that responding party has to select at least one mediator from that list when respond within 20 days. And the response has to be provided by certified mail, return receipt requested. I can't tell you how many times when we send mediation demands to owners that they fail to respond in accordance with the statute. It's fairly commonplace, unfortunately. So the mediation must be scheduled to be held within 90 days of the date of the written demand, unless the parties agree otherwise. The parties share the cost of the pre-suit mediation unless they agree otherwise, and the mediator can require advance payment of their fees. A lot of times when excuse me, my voice is failing me. A lot of times when the owners are pro se or there are pro se parties, that is the requirement, where the mediator will require advance payment of their fees. Pre-suit mediation proceedings are privileged and confidential, as I mentioned before. Persons who are not parties to the dispute cannot attend the pre-suit mediation conference without consent of all parties, again, because it's confidential, except for counsel for the parties and a corporate representative designated by the association. Now, when you're at a mediation and the association is a party, you obviously need to have the players who are making decisions for the association there, because the whole point of mediation is to enter into a settlement agreement. So you need to have the people who are able to authorize that settlement agreement there, which usually means a quorum of the board. When a mediation is attended by a quorum of the board, the mediation is not considered a board meeting for the purposes of notice and participation of owners. Again, these are confidential, privileged and confidential undertakings. So even if your board quorum is there, this is not something that you're posting a board meeting notice for and inviting owners to attend. Now, an impasse means we can't go any further with this. So an impasse entitles a party to go directly to court without further notice. And they can seek an award of attorney's fees associated with that mediation. And there are a number of things that can trigger an impasse. Either the party fails to respond to a demand or response, they fail to agree to a mediator, they don't make payments, they don't appear at the mediation, or the mediation can't be scheduled and conducted within that 90-day period unless otherwise agreed by the parties. So there are a number of things that can lead to an impasse, and an impasse means that parties can go directly to court. If the pre-suit mediation is not successful in resolving disputes between the parties, then they can file that unresolved dispute in court or elect to enter into binding or non-binding arbitration. If the parties don't agree to arbitration proceedings following an successful pre-suit mediation, then any party can go and file into court. A final order resulting from non-binding arbitration is final and enforceable in the courts if a complaint for trial de novo is not filed within 30 days, as we discussed before. With regard to attorney's fees, in the event the person who fails or refuses to participate in pre-suit mediation process prevails, then they cannot recover attorney's fees and costs of subsequent litigation. Meaning, you caused the impasse, now we're in litigation. Yeah, you won, but because you didn't participate in mediation, you're not going to get prevailing party attorney's fees, right? It's a slap on the hand for not participating in mediation. If a dispute's not resolved in pre-suit mediation and the prevailing party in a subsequent arbitration or litigation is entitled to seek and recover all attorney's fees and costs incurred in the pre-suit mediation process. So if you guys did do mediation, it was brought to further proceedings, whoever wins those proceedings can get their attorney's fees and costs that were incurred in the mediation. If the dispute was settled at pre-suit mediation, but an action seeking enforcement of the mediation settlement is sought, then the prevailing party in that litigation or arbitration proceeding for enforcement of that mediation settlement is entitled to seek recovery of their attorney's fees and costs incurred in that pre-suit mediation process. So essentially, it's like a slap on the hand for not complying with that pre-suit mediation settlement agreement. And now, let's say all of that fails. Now we're into litigation. As I discussed earlier, there are actions at law or in equity or both for the association or a failure to comply with the governing documents. There are different parties that can take advantage of these causes of action, including owners versus owners. And a lot of times we run into neighbor-to-neighbor disputes where the owner can take the provision of the declaration and enforce it against their neighbor. Let's say it's a nuisance issue. So owners can bring actions under the declaration against another owner. But most of the time it's either association versus owner or vice versa. But there are a number of different parties that can actually take this on. Generally speaking, the prevailing party in a litigation is entitled to recover reasonable attorney's fees and costs. A member that prevails in an action between the association and that member, in addition to recovering their reasonable attorney's fees, can recover additional amounts determined by the court that it may be necessary to reimburse them for their share of assessments that were levied by the association to fund that litigation, right? So they're not even going to pay their portion of assessments pertaining to those attorney's fees. Now, here are some of the things that board members need to be aware of when it comes to litigation or possible affirmative defenses. This is not to teach you how to get away with these things per se, but to present some scenarios or at least make you knowledgeable about ways to avoid these things because you want to do it the right way. If a selective enforcement, I'm sure you guys have heard selective enforcement many times. If the community association fails to uniformly enforce their covenants and restrictions against all owners, then an owner against whom the association is taking enforcement action can raise the defense of selective enforcement. To prove selective enforcement, it really needs to be an apples and apples comparison, not apples to oranges. Selective enforcement is limited to similar violations because where the governing body, here the board, has the authority to interpret its rules and regulations and decide which violations to pursue, its decision will not be subject to the defense of selective enforcement unless it's shown to be irrational or unreasonable. So maybe the association doesn't have the funds to seek enforcement against every single one at the same time. Well, the mere fact that the association has someone on a list and isn't able to get to that violation isn't going to form the basis of a selective enforcement for someone who's higher on the list. The owner has the burden of proving that there were other similar violations that the association had knowledge of and chose not to take any action or to attempt enforcement of that rule. If selective enforcement is raised as a defense in an arbitration, the answer must contain all examples of the selective enforcement which they're relying on. Identify the units to which they pertain. I mean, there's a lot of, it's heavily factual. And there are some examples of where selective enforcement was shown and not shown that you guys can take advantage of, because I know we only have like 1 minute left. The following different lists of affirmative defenses really pertain to time after equitable estoppel. So equitable estoppel is that person did it, the association didn't take enforcement action against them, so I'm going to do it too. It's basically relying on what is considered a representation of a material fact by the association, relying on that, and then changing my position on that reliance. And that can be raised as an equitable estoppel defense. Some examples are provided there for you. Latches simply means that the association unreasonably delayed in seeking this enforcement. They knew about it, they waited so long in order to enforce this, therefore they don't have the ability to do so now. There's, again, some examples for you there to read on your own. It's very similar to waiver, except that waiver pertains to that particular privilege or right and not necessarily enforcement in that particular instance. So maybe there is a truck prohibition in your governing documents, but the board hasn't enforced that truck prohibition in 3 years, whatever it is. And all of a sudden the board starts enforcing it and sends you a demand letter and says, no, you got to get your truck out of here. Well, the owner can then say, no, they waived that requirement in the governing documents. They've allowed people to have trucks in here for the past 3 years. They can't just start enforcing it now. So that would be in the context of a waiver. And there are some examples for you as well. So I think I've gone over 1 minute, and I'm glad you guys stuck with me. If you have any questions, I'll stick around and do some questions with you guys, but do feel free to send me an email. Like I said, I do try to respond to them to the best I can, as quickly as I can. And if you have any other, legal questions and you need legal assistance for your association, feel free to reach out and contact KBR.
Wonderful job, Danielle. I'm glad you're feeling better too. And yeah, we'll go over some of the questions in just a second. Peggy, if I may, I want to just go over something real quick. I had a power surge during the presentation, so when I was saving the slides, it didn't save properly. Some of you got slides for a different class after filling out the evaluation. I resaved it, tested it, should be fine now. But when we email everybody their certificates within 5 or 7 days or so, probably less, but I just give a little time. When we email everybody their certificates, there'll be another opportunity to do the evaluation, and I'll have the slides link there as well if you don't have them now. But I also place the slides link again into the chat just in case. So, but anyway, Peggy, before we go to some of the Q&A, anything you'd like to mention for anybody who may need to rush out of here?
Sure. I'll go on and do the closing. I do have some announcements for everybody. First of all, I just want to say thank you, Danielle, of course, and Jeff. Great information. I wanted to mention some of the upcoming webinars and events. So starting next week, I've got Sherwin-Williams on December the 9th, going over their products. December 11th, 8 to 4, there's a trade show called the Cooperators HOA and show at the Fort Lauderdale Convention Center. And I mention that because from 8 until 12, there's a 2025 board certification class available for those that are in the area of South Florida. So If you want to go there, 12:16, I have another webinar, 2025 board certification from 12 to 2 virtually. That's totally virtually. And then we go into January, and I'm just going to leave it at that because I have put all these on my website, which I did not mention. My website is under flcondovendors4u.com. I'll mention that in my follow-up email with all the things attached going on through with the sponsor sheet, etc. So you should be able to find that. I'm just going to say happy holidays, and thank you again for choosing to come on our webinars. So back to you, Jeff.
Well, Peggy, very well said. Thank you for having us. We appreciate that. And folks, just so you do know, once you've done the evaluation, the required part is over. The Q&A is a little bit of bonus time. And Peggy, with your permission, maybe 5 more minutes to do a handful of the questions. Is that cool with you?
Absolutely. Absolutely. For whoever wants to stay on, sure.
Sure. Danielle, are there any burning, or would you like me to go through a few that are pertinent to the topic?
I haven't, you know what? I should have been looking this whole time and I didn't.
Then I'm happy to do it. Happy to go over.
Please.
So one of them here is a common one from Karen. Is smoking considered a nuisance?
So it depends. It could be. It could actually be considered a trespass, in fact, because
Really?
the smoking, it has to do with the particulate, right? And usually the smoking issue, when it comes to a trespass is more so in a condominium context, the person above you who's smoking and all their ashes are coming onto your balcony, something like that.
Right.
So it might be, nuisances are very fact heavy, and it has to be something that's persistent. So potentially, maybe is my legal answer.
Potentially, maybe, perhaps.
Perhaps. It really is fact intensive. And usually a lot of times associations, I do like to say this also, associations are not the police. So if you're having an issue with your neighbor, or if you're frightened for your safety or something like that, you really need to be calling the police owners. You don't call the association. The association's not the police. Yeah. But when it comes to these particular types of nuisances, this is a great example of a neighbor-to-neighbor dispute where owners have the right to bring an action against their owner using the provisions of the declaration. So they can use that nuisance provision against their neighbor, even though it's the association's governing documents. This is really an agreement that all owners enter into when they purchase the property. So they're all bound to it. So, just have that in your back pocket as well as an association, board member or manager about the neighbor-to-neighbor disputes.
Okay.
But smoking, it could be. It could be.
Yeah, I think a lot of folks refer to the smell, especially like with medical marijuana these days being legit down there, and the answer can't just be, well, take an edible. So people are.
We also hear it when it comes to allergies for animals. I
Right.
moved into a pet-free community, and now there are all these animals in here. Well, they're emotional support animals, and usually, you have to do a weighing thing. Like maybe if you're allergic to dogs, maybe we need to make some kind of accommodation for you as well to put in an air filter or something, because the person is still entitled to have their animal there, and you're
Right.
entitled to live there in peace. So we need to be making, entering into an interactive process there, which is, it's another presentation.
It's a whole. We could talk all day.
On its own, yeah.
No doubt.
I did see a question here about how to collect a fine. So for our condominium associations, you're going to be looking at a money judgment. You're going to be going into court to collect on that fine if it's not paid, because it cannot form the basis of a lien. Certainly something you might want, consider adding to your estoppel. I think that, it's fair to do that because you do have the ability to put in there any active violations.
Yeah.
But for our HOAs, if your fine is $1,000 or more, you can lien for that. You want to be looking at your declaration, though, to make sure that you have the authority to assess for those fines. And if you don't, amend.
Okay. Now, folks, if I'm skipping your question, it doesn't mean it's a bad question. It just means we have tons of them with only a little bit of time left. So I am skipping around, admittedly. But Danielle will receive all of the Q&A report and everything, and Peggy will receive it. So we'll, and you could also ask your questions on the evaluation, and Danielle will do her best to respond if it's not teetering on actually giving legal advice, of course. Can a board member be on a finding committee in an HOA if they are not a director, officer, or employee of the HOA?
Can a board member?
Can a board member be on a finding committee in an HOA?
No.
Okay.
If you're a board member, you are a director.
Right.
Therefore,
So I
you
wanted to
cannot be on
clarify.
the finding committee.
That's
Yeah, so a rose by any other name. Sometimes we have them called board of governors, and they refer
right.
to themselves as governors. You are still a director for the meeting of the statute and cannot be on the finding committee.
Okay. And that goes hand in hand with terms in this business being thrown around way too loosely. Like the acronym
Right.
HOA. What do you pay your HOA if you live in a condo? And that's how all this confusion lends into. There's a lot of confusion about who's a director, who's an officer, and what are my roles. So
Right.
that's why I wanted to
Right.
bring that one up. Thank you, Danielle. Let's see here. Can an HOA board member have a family member related, son, wife, brother on a committee or a violation committee? So if a family member lives in the community, can they be on the committee if the HOA board member is a family member?
So, no.
Probably, right?
No,
I mean,
no.
it's going to be a spouse, a child, brother, sibling. You can't be on the finding committee.
Okay. Not
It
so
has to be
immediate.
a different residence, right? Different residence. Let's say your brother lives in the community. Your brother could be on it if he's a different resident of the HOA.
Not if you're on the board. If
No.
you are on the board
resident.
and
Like if you have a family member living in a different parcel in the HOA, in a different home, and you
but
are
if I am a board member and my brother lives in the community and he wants to serve on the finding committee, he can't because I'm a board member.
okay, that's what I wanted to clear up because this person I think is trying to relay that they live in a different house, but still a family
Yeah, it's
member.
not
of the
about
board member.
household, it's about the relationship.
Got
the
it.
familial relationship.
And that's why we wanted to clarify. You were wonderful. That's
Yeah.
why we call Danielle affectionately the walking encyclopedia, by the way. So let's see here. Let's do a couple more. I know it's been a long morning here. Let's skip down a little bit. Okay, regarding the $1,000 max fine per aggregate, does the $1,000 only apply to the one specific violation at that time? So, for instance, if they are a repeat offender and violate the same thing, they are fined for within the same year, or can you fine them again for the same thing?
You can find them again.
Okay.
You can find them again. So let's say in a condo or HOA, if the HOA doesn't allow the fine to exceed $1,000 in the aggregate in the governing documents, that's the assumption we're making here, right?
Mm-hmm.
We have the dirty roof. You fine them for the dirty roof. They don't clean it. They don't clean it. They don't clean it. You meet the maximum $1,000. Well, the next day it's still dirty. You can do another fine and rack that up to $1,000. Still not clean? Do another fine. And you can just keep adding those. I mean, yeah, you can continue adding it, but you still have to follow that double process, the board levy and the hearing.
Had a very interesting scenario when I was running a property in that we had a very well-to-do owner from New York City. Again, like I said, well-to-do. This person had money. She would constantly park where she wasn't supposed to park for our theater shows. And when we approached her, we said, why do you continue to do this? We keep giving you tickets. She's like, I'm from New York City. I'm used to paying $80 a night to go see a Broadway show. So these $20 parking tickets, keep giving me the tickets. I don't care. I don't want to have to walk too far.
Right. Yeah, and sometimes when we're looking at covenant enforcement, our goal should not be to penalize. Our goal should be compliance.
Right.
And I think a lot of associations want to go down the fining route because they think they're sticking it to them.
Right.
But ultimately, the juice may not be worth the squeeze, considering the procedures that you have to follow and the statutory dollar amounts that are involved, limitations that are involved.
Yeah.
That you're better off doing that neighborly approach where you send the notice, provide them with the opportunities, And then instead of doing some kind of fine, well, then maybe we go into the pre-suit mediation process where we can sit down at a table. Well, not a literal table, but because everything's done by Zoom now, everybody goes into different Zoom rooms, and come to some kind of agreement and consensus rather than issuing penalties. But the option is there.
Okay. Peggy, I promise one more question, and then I'm just going to help everybody with their evaluation one last time. Okay. Is that okay?
Yes.
Okay. Thank you. Thank you. Thank you. Okay. So this one comes up quite often. I'm trying to pick questions that are frequently asked. Documents dating back to the early 2000s or earlier do not have all of these language updates that you spoke about today. So will our HOA documents need amendments or updating to comply with current laws, or can they stay the way they are?
So it depends if you have Kaufman language or not. If you have Kaufman language that as amended from time to time, technically speaking, you don't need to amend the declaration to take advantage of all these different things that we were talking about just now. You certainly can, but you don't have to, because when it comes time to analyze your governing documents and provide some kind of legal interpretation of it, those things get incorporated into your documents as if they were initially drafted in them by virtue of that as amended from time to time language. But if you don't have Kaufman language, then yeah, in order to take advantage of those substantive changes to the law, you do need to amend your governing documents to incorporate them. Now, when it comes to certain procedural aspects, like the number of days of notice, or, for example, the trash cans, you have to wait 24 hours before you can fine for them. Those procedural changes are going to apply to your association regardless of the fact that you have Kaufman language or not. But the substantive things, the actual rights, like the voting right suspension, if you don't have it in your governing documents, you want to be sure that you're amending your declaration to include that. If you don't have Kaufman language and it's not there.
Okay. And then two rapid fire ones here. At the end, who has the final decision on these fines? Is it the board or the grievance committee?
Committee.
Okay. And then when do you apply self-help?
So depends. What is it that the issue is? So first of all, you need to have the authority in your governing documents. If you don't have the authority for self-help in your governing documents, you can't take advantage of self-help. If the association has the money on hand to actually do the work, and because remember, you're going to have to back bill this. This is something that you can collect the money for first. This is something where you're charging whatever fees were incurred from the association's work. And whether or not it's feasible to actually do the work. Like if it's, repainting someone's home, maybe that's not something that's feasible because it requires multiple days of being on the property. Or if it's something like cleaning the roof, that might be something that's feasible for the association to do. And, we also have to look at what DCA are you in? Like I mentioned before, self-help may be something that you have to attempt to do before you can go into a litigation standpoint to get an injunction to force the owner to clean their roof or paint their home. Here in the 4th DCA, we don't have that issue right now because there's a controlling statement that says, no, we don't, you can go the injunction route versus having to do the self-help route. But if you're in a 2nd or 6th DCA, 2nd DCA, I think is like the Tampa area, 6th DCA is down south. Then you would be looking at doing the self-help. And a lot of times what we'll do in that scenario is we'll issue the self-help and the pre-suit mediation at the same time so that they're running concurrently. So that when you get to the point of, okay, maybe it's time to go litigation route, you've kind of ticked the boxes of having done self-help, having done pre-suit mediation to save you guys some time to the litigation. But whether you choose to actually go self-help litigation route versus doing fining and suspension of use rights, I mean, it really depends upon the nature and the tenor of your community. It's a decision for the board to make.
Okay. Good answer. Good answer. I think people want to get out of here, so I'm gonna let the.
No problem.
I know you have appointments.
It's nearing lunchtime anyway, right? Maybe not for you, but for us here on the East Coast, in Eastern Standard Time, it's nearing lunch.
Well, I know
One
you have
last
some.
question for Jeff, excuse me.
Go ahead. Sure.
If I send this link out to the survey with my things, is it going to be good for another length of time, or is it just for this class?
Oh no, yeah, this link is specific to this class, so you can send it out with your post as well. That'd be great. We appreciate that. And for those of you who are saying that it's not working, think of it as like when Taylor Swift tickets first go on sale, and everybody's trying to do it at the same time, and the website just times out. So I have over 140 of you already submitted it, but I have one person in the chat saying that it's being blocked for you. Francis, just try it again. You might be trying to do it at the same time as many others, but it is working. And I have, like I said, over 140 submitted already. So just give it a shot again, and Peggy will send it out in her post-webinar email, and we will also send out another evaluation link when we email you your certificates to the email addresses you used when you registered. So with that said,
All right. Thank
Peggy,
you
I'll leave
guys
it
so
to
much.
you.
Thank you, Peggy, again. Thank you to our sponsors.
Happy
And I hope to
holidays.
see you guys soon.
Happy holidays,
Happy
everybody.
holidays, everyone.